This video is for informational purposes. It is not legal advice. You should contact your local Citizens Advice to get help with your particular issue or problem. To find your local Citizen Advice, visit www.citizensadvice.org.uk. Hello, Adam from East End Citizens Advice here. Welcome to the fifth of our videos about employment rights and the second of 3 on dismissal. Following on from our first video on dismissals, this video, Process and Exceptions, deals with the exceptions to the 2-year qualifying employment rule and what constitutes a fair procedure. If you have not watched the first of our videos on dismissals, we would strongly recommend that you go back and watch this first before continuing with this video. Just to briefly recap then from that first video, firstly, you must be an employee to challenge a dismissal. How to decide on what your employment status is was covered in our first set of videos on employment status. Secondly, you have to be employed for 2 years to challenge a dismissal, but there are exceptions to that rule, some of which we'll be covering in this video. Thirdly, there are 5 potentially fair reasons which an employer can give to lawfully dismiss. Finally, there are 5 basic elements to any fair dismissal process. How these apply will depend on which of the 5 reasons an employer is relying on to dismiss someone. With that in mind, what we will be covering today will be some of the common exceptions to the 2-year qualifying period of employment for unfair dismissal claims. We will then be dealing with the basic elements that must be present in dismissal proceedings when an employer is dismissing on the basis of conduct, that is when you've done something wrong or otherwise relating to your conduct in the workplace. Capability, that is the ability to do your job, including whether or not you are too ill to work. Legality, that is whether there is any legal barrier to you doing your job. The final 2 reasons, redundancy and some other substantial reason or SOSR dismissals, are covered in our next video. Turning then to the exceptions to the 2-year rule. And it's important to understand first of all that although there are many such exceptions, they each have a lot of different elements you need to satisfy before you can rely on them. Where an exception applies, it is known as an automatically unfair dismissal. It should be noted, however, confusingly, that whilst most reasons that are automatically unfair are also exceptions to the 2-year rule, there are a minority that are not. For a dismissal to be automatically unfair, it must be for one of the reasons set out in the Employment Rights Act 1996. Whilst that Act may refer to other legislation, whistleblowing, for example, is based in part on the Public Interest Disclosure Act 1998, the right to claim automatic unfair dismissal must be within the Employment Rights Act 1996. A common misconception is that because a dismissal was potentially discriminatory, this means it is automatically unfair. This is not correct. Discrimination is largely, if not entirely, dealt with by the Equality Act 2010, not the Employment Rights Act 1996. This is a much more complicated area of law, separate from dismissals, and we will be covering it in a future video. That being said, some of the most common exceptions, to give you an idea if you might have a case, are whistleblowing. We'll deal with this in more detail in a separate video, but broadly speaking, this is where you have been dismissed for raising an objection to either a breach of legal regulation or a breach of health and safety issue. Pregnancy. If you can show that your employer dismissed you because you were pregnant, this is automatically unfair. This is potentially also discriminatory, but to be clear, as stated, these are separate issues. Pregnancy is only an automatically unfair reason because it is expressly stated at subsection 99 of the Employment Rights Act 1996. Raising a protected employment right, what is often termed assertion of a statutory right. To repeat what was stated earlier, these are only rights that are listed at subsection 104 of the Employment Rights Act 1996. However, this covers many of the common rights, meaning that if you are dismissed for raising potential breach of your right to be paid your wages correctly, paid holiday, or to ask for a written contract, then you may have a right to claim automatic unfair dismissal. Turning now to the process to be followed in a conduct dismissal. Firstly, you must see if the matter is a conduct issue or not. This is not a difficult test to satisfy, as all you have to do is, as an employer, show it was an issue relating to the employee's conduct. That being said, this is worth considering, as sometimes an employer can confuse an issue of conduct, i.e. your actions and behaviour, with capability, i.e. whether you are good at your job or not. Secondly, it must be understood that whether you have committed the act of misconduct or not doesn't matter. What matters instead is whether your employer is able to show that it had a reasonable belief in the misconduct, it had a reasonable basis for that belief, and that dismissal was within the reasonable range of responses. In looking at these, you still need to remember and fit these within the 5 stages to a fair process from the first video on dismissals. Finally, gross misconduct is not the same as misconduct. Misconduct is only gross where your actions are so severe your employer cannot possibly allow you to continue working there a second longer, hence why you are not entitled to notice pay if you are dismissed for gross misconduct. Examples of gross misconduct may be given in your employee handbook, but it is not for your employer to decide on its own, and it will depend on the facts of the case. Common actions that might be described as gross misconduct may include physical violence towards a colleague, persistent failure without good reason to attend work, or theft of property belonging either to your employer or fellow colleagues. Moving then to capability dismissals. Now again, the 5 steps still apply, as with all dismissals, but unlike with conduct, capability is more formulaic. That is, it doesn't matter whether your employer believes you are not capable, it is a matter of whether you are or you are not. Whilst again all 5 steps are relevant, your focus should be on informing you that there is a problem. This is either that you have taken too many sick days, or alternatively your performance has decreased in recent months. That the facts should be established. So, if it is a sickness issue, that means a referral for an occupational health review to see how, if at all, you can be assisted. Alternatively, if it is a performance issue, this will usually mean follow-up meetings. Finally, appropriate action must be decided. If you have one, look at your contract or employee handbook. Capability reviews will usually involve a 3-stage process, usually called something like a sickness review or a performance management review. It isn't unlawful as such not to follow that procedure. The key is always the ACAS guidance, but it does not look good if it's not followed. It could be used as evidence of an unfair process. Turning then, finally, to legality dismissals, which are very similar to capability dismissals in that, again, there is a formulaic application of the 5 key elements of a fair process. Again, it is not based on belief, but whether, first, that there really is a relevant legal regulation, and second, that the legal regulation actually prevents you from being employed. So again, the focus should be on the same things as with capability. That is, informing you first of the legal regulation that your employer states you are in breach of, and then establishing the facts via follow-up meetings. In cases where your employer believes your immigration status does not allow you to work in the UK, and you think it's wrong, you should always try and signpost it to the employee checking service. Appeals are particularly important in legality dismissals. They allow an employer to correct any mistake about its understanding of the law. Alternatively, if it does not carry one out, this does not look good and is a major indicator of an unfair process. So once again to the takeaways, and what we've spoken about today is, first, you can sometimes challenge a dismissal without being employed for 2 years. Second, these exceptions are very limited, often hard to show, and have to be undertaken in a certain way. Thirdly, the reason given for the dismissal shapes the process. So, for conduct dismissals, the process must show that the employer had a reasonable basis for their belief in the alleged misconduct. In capability dismissals, the process must show that the employee actually could not do the job, not just that the employer believed that he, she or they could not. Similarly, in legality dismissals, the employer must, whatever the process followed, show at the end of the day that there was an actual legal barrier to employment, not just a perceived one on their part. And that brings us to a close. We hope you found this video useful. The next is our 3rd and final part of our 3 videos on dismissals. That video deals with redundancies, dismissals for some other substantial reason, and where you are forced to resign, or constructive unfair dismissals.